Ladies and gentlemen, boys and girls, hello, namaskar, and welcome to Law Charcha. I know this video is coming after a long gap. It was because I was occupied with my LLM exams. I thought the pandemic forced lockdown could be an opportunity, a good opportunity to do a lockdown forced studies through the LLM program of Maharashtra National Law University, Mumbai. I had been reading the comments and queries on our channel. I also try to address those queries through my videos. One such query was, what options does an accused have if police denied to take certain documents or did not include those documents into the charge sheet, which could be or could have been rather pivotal for the accused? I will address this query during the course of this video. Further, in this video, I will also be dealing with some conflicting case laws and put open to all of you to comment what is the proper resort in case of a conflict in cases in the judgments. Of course, I would also be giving my input on the same. Let's begin with addressing the query of our friend. On many occasions, it may happen that upon registering an offense, the investigating agency may not carry out its duties properly and its responsibilities honestly. In such situations, it may happen that the charge sheet filed by the investigating officer or the investigating agency before the court is devoid of some crucial documents which contain information, important information. It may happen that police do not include all these documents, all the evidences that could prove the offense, or for that matter, prove the innocence of the accused by filing a closure report. The police, by virtue of the powers that they receive under various laws, may be able to influence the investigation and thereby favor a particular party. In such cases, one may wonder what remedy would victim or complainant, or for that matter, accused, would have if the investigation is not being carried properly and evidence is not being collected properly. Imagine if the police, just because of the guidelines of the Honorable Supreme Court in the case of Lalita Kumari versus State of UP, register a case in a cognizable offense merely as a checklist of the compliance under the said judgment. And if their intention is not to conduct the investigation responsibly and with integrity, they may sometimes delay investigation and may also file a weak or a negative report, that is, a weak or a negative charge sheet, thereby making it convenient for the accused to escape from the clutches of law. The complainant on such occasion can approach the High Court seeking transfer of the investigation. In this scenario, the High Court may order transferring investigation from one police station to another or from one investigating agency to another. A reference of a Supreme Court judgment in this regard would be relevant. In Bhagwan Singh's case, situation has been explained well. So when the report forwarded by the officer in charge of a police station to the magistrate under section 173 comes up for consideration by the magistrate, one of the two different situations may arise. The report may conclude that an offense appears to have been committed by a particular person, and in such a case, the magistrate may do one of these things. First is, he may accept the report and take cognizance of the offense and issue process. Second is, he may disagree with the report and drop the proceedings. And third, he may direct further investigation under section 156(3) and require the police to make further report. Then the report may, on the other hand, state that in the opinion of the police, no offense appears to have been committed. And where such a report has been made, the magistrate again has an option to adopt one of the three courses. First is, he may accept the report and drop the proceedings. Second is, he may disagree with the report and taking the view that there is sufficient ground for proceeding further, he may take cognizance of the offense and issue process. And third, he may again direct further investigation to be made by the police under 156(3). Apart from seeking transfer of investigation by approaching the Honorable High Court, a complainant can even approach a magistrate and pray for further investigation if there are discrepancies or incompleteness in the investigation. The remedy in suitable facts of case to pray for further investigation before the magistrate has been ratified by the Honorable Supreme Court in Vinay Tyagi versus Irshad Ali. Though the Supreme Court strangely held that the magistrate cannot order for re-investigation of the matter and can order further investigation. The judgment finds this phenomenon apparent from the harmonious reading of two provisions enumerated in the CRPC. First provision is section 173(8). By reading the section, categorically one will understand that this section speaks about further investigation, empowering the investigation agencies to carry any further investigation. Second provision is 156(3), which empowers the magistrate to direct the investigation, which includes further investigation, but excludes the power of the magistrate to direct re-investigation and or further investigation. This proposition that a magistrate can order further investigation is what the Supreme Court in Vinay Tyagi's case has settled, trying to put an end to this grey area with respect to power possessed by a magistrate with regards to further investigation. Now, before the Supreme Court's judgment in Vinay Tyagi's case, which I referred, it will also be wise to know from where this issue of further investigation came into light and how law on the same was developed. It is known that in the earlier Criminal Procedure Code, the provision of 173(8) was not available. For the first time in the year 1919, the Madras High Court had an occasion to deal with issue of further investigation in the case of Divakar Singh versus A. Ramamurthy Naidu, where the court had to deal with a contention that when a report of investigation has been sent in under section 173 CRPC, the police has no further powers of investigation. And the court opined that the number of investigations into a crime is not limited by law, and that when one has been completed, another may begin on further information received. Now, later, a three-judge bench of the Supreme Court in H.N. Risbad versus State of Delhi recognized the power of police to make repeated investigation under the old Code of Criminal Procedure. The incompleteness or lacuna in the old Code of Criminal Procedure with respect to provision of further investigation, that is, whether police can or cannot do it, was apparent from the judicial decisions. The same was recognized by the Law Commission in its 41st report, and it was recommended that the power of the police to make further investigation should be statutorily affirmed. Accordingly, in the Criminal Procedure Code of 1973, section 173(8) came to be introduced, which statutorily made provision for the police to undertake further investigation after submission of the final report under 173(2) of the CRPC. Pertinently, the magistrate's power always existed even in the earlier provisions, and in H.N. Risbad's case, the Supreme Court has recognized the power of magistrate not just to further investigate but also to order re-investigation. As you can see, it was observed that when the breach of such a mandatory provision is brought to the knowledge of the court at a sufficiently early stage, the court, while not declining cognizance, will have to take the necessary steps to get the illegality cured and the defect rectified by ordering such re-investigation as the circumstances of an individual case may call for. Interestingly, the judgment of Vinay Tyagi, which is a two-judge bench judgment, did not refer to the judgment of H.N. Risbad, which is a three-judge bench judgment, which had clearly and completely settled the issue with respect to investigation. there could not have been any reason for any question on this point for the Supreme Court to settle. Unfortunately, the trend has been to rely on newer judgments, and in cases of conflict, subsequent judgment or the newer judgment is given weightage as against the older ones. According to me and the principles of precedence which I learnt or which were taught to me, if there is an existing larger bench judgment, then for taking a contrary view against that judgment, the said judgment has to be overruled. And for overruling, a larger bench has to be constituted. According to me, the law laid down in H.N. Risbath's case holds good, and the law laid down in Vinay Tyagi might require relooking or reanalyzing. I don't know. Of course, this is an academic discussion. For practical purposes, for arguing this point before the magistrate, one should strategize the submissions to suit the case and also consider the best interest of the client. One has to understand that these provisions and remedies are not only available to the complainant but available to an accused also. But additionally, and upon a proper advice, an accused can in fact take benefit of incomplete or irresponsible investigation, where such an accused can file an application for discharge and seek a discharge from the proceedings if prima facie case is not made out from the investigation or from the charge sheet, which I have dealt in my video on discharge. But a situation may also arise that certain document which is actually favoring the accused is conveniently dropped from the charge sheet by the investigating agency. In such a scenario, the accused can also use the provisions for production of documents when the accused is aware about the custody of the document. The accused can also mention the additional facts which he wishes to bring on record during his statement under section 313 of the CRPC. Furthermore, he can examine himself or other witnesses to bring on record such material which did not form part of the charge sheet. Needless to mention that in doing so, the accused would be exposing himself or herself to the cross-examination at the instance of the prosecution. So the sum and substance is that there are many options available to the accused as well as the complainant in cases where the investigation is not conducted properly. Whether or not to choose a particular remedy would require a holistic study of the case and the case laws that would enable a comprehensive outlook towards a particular matter. This is also where aspects of a good litigation management come into picture. On this note, I will try to deal with litigation management and what are the good docket management practices through my videos in future. For now, thank you for watching Law Charcha. Keep watching our videos. Do share, subscribe our videos. Thank you. Take care. Namaskar.